So our next speaker this morning is Professor Prabuddha Ganguli. Professor Prabuddha obtained his PhD in chemistry from the Bombay University. This was followed by postdoctoral research in Germany as an Alexander von Humboldt Foundation Fellow and in Canada. He held the Ministry of Human Resource Development, IPR Chair Professorship at Tesbu University, Assam, India, from May 2012 to July 2017. He is Honorary Scientific Consultant for Innovation and IPR Matters to the Office of the Principal Scientific Advisor, Government of India, a member of the Advisory Board of the IIPI, Washington, and a member of the International Editorial Board of World Patent Information. This is since July 2017. He is also visiting professor at the Rajiv Gandhi School of Intellectual Property Law in the Indian Institute of Technology, Kharagpur. He was awarded the Chemtech Pharma Bio Award in 2011 for outstanding contribution in the field of intellectual property, the Lifetime Achievement Award by the Legal Era in 2014 for his continued contribution in the field of IPR, and the Excellence Award by the Tata Institute of Fundamental Research Alumni Association in 2014 for his contribution in the field of technology, management, and IPR. So Professor Ganguli will talk about delocalizing knowledge, IPR issues holding the keys. Please welcome.
Thank you very much.
So I need to show you when it's 10 minutes to go. And 5 minutes.
This is the one? Okay. A very good morning to all of you. Indeed, it's a great pleasure to come over for this particular workshop. What I'd like to do is, rather than go into great details of it, I'm sure in the last 2 days you must have had several talks on this subject, but what I'd like to do is to look at this whole issue of how do you delocalize knowledge, right? And what is the role of intellectual property rights in this process of delocalization of knowledge? So first of all, what I'd like to do is just go across and to say that for sustained societal growth, something that we need is excellence, inclusion, and fairness. It's a dynamic synergy between creativity and society. And we all know that wellsprings of knowledge are education institutions, R&D institutions that have to interact with what I call as knowledge irrigation channels. Deriving this particular terminology from agriculture, that unless you irrigate, okay, you need irrigation channels. These irrigation channels are industry and different types of institutions. And of course, the government has to be a great facilitator in this process. And law, in my opinion, is only a framework of self-governance and behavioral norms. So the point is that we need to really look at this holistically rather than looking at it in a very narrow sense of this particular term. Keeping this in mind, that we are talking about a very holistic approach to this particular subject, I then go into what I call as a knowledge canopy. And in this particular knowledge canopy, if you hold knowledge in your hand like this, and you have an umbrella, and these are the different spikes there, what do? We are accessing knowledge, we generate knowledge, and I differentiate between generating knowledge and creating knowledge. So we generate knowledge, we also create knowledge. Many a times and very often we share knowledge, we barter knowledge. I give you something, you give me something. We share, we barter. We sometimes trade with knowledge, we apply knowledge, and also fairly often what we do is we hold back knowledge for variety of reasons. We hold back knowledge. So in this whole paradigm of what I call as the knowledge canopy, two very important issues, play. And that is intellectual property rights on one side, and the other side is how do you secure information, while keeping in mind that you need to share, you need to exchange, you need to do everything. And how do you bring these two seemingly conflicting concepts in one framework? And therefore, as a user of this particular knowledge, the question that we are hounded with is how does one navigate to the public and private knowledge domains? That means what we are saying is that the entire knowledge domain has two components. One is a public domain part of it, the other is a private domain, but available to the public. Right? So it's not, the public is not deprived of it, it's available to the public, but it's private. For example, while entering this gate, it says UNESCO. It's not that everybody can enter. Public can, provided you have access to it, provided you have been given access to it. So this is a private domain, right? Whereas the open parks, however polluted they may be in Delhi, it's completely open to public. Anybody can walk in. So the knowledge domain has this same concept out there. So the question is that you have a private property, you have public property. The question is, how do you navigate through this particular bit? Sorry, what happened? So now they come to two concepts. And the two concepts are very important. One is when you use my knowledge with my consent, and when you use my knowledge without my consent. So when you use my knowledge with my consent, you're prospecting my knowledge. When you're using my knowledge without my consent, you're pirating my knowledge. The question is, how do you look at it? And therefore, when I say it's my knowledge, I'm talking about ownership. The word my is something about ownership. That means somewhere there is a concept behind my mind that I own that particular knowledge. But if I gave you my consent, you're prospecting my knowledge. If you're using my knowledge without my consent, you are pirating my knowledge. So the concept of where does this intellectual property rights issue come in is all about prospecting and pirating. And when does this come into force? The dynamic says when you begin this concept of ownership. So ownership is a very, very fundamental issue in this particular game. Who owns knowledge? And when do you begin to own the knowledge? Whereas we recognize that you created the knowledge or you generated the knowledge. That's fine. But do you own the knowledge? Is the question. We do not question who created the knowledge or who generated the knowledge. The question is, do you own the knowledge? So the question that comes in, just by my having created the knowledge, do I automatically own the knowledge? So we need to really look at this particular aspect very, very carefully. And this is the crux of entire thing about intellectual property rights. So we go further into an area that when I begin to own knowledge, are we sort of creating what I call, and is a term derived from astronomy, black holes of knowledge. You know, black holes in astronomy are spaces where all the energy gravitates, matter gravitates and gets locked and doesn't come out of it. So are we creating a situation where we are creating black holes of knowledge, that it gets in and doesn't come out? Is it really useful then? So the question is that in a shrinking open knowledge domain, so today, as we speak, in the total knowledge space, the space which is open in the sense of free use is shrinking. Proprietary knowledge is increasing, so the density of proprietary knowledge is increasing, the space of open knowledge is actually shrinking. The question is the whole concept of intellectual property rights creating black holes of knowledge, or are they opening up processes? So that's question number one. Question number two, which is very important, is that when we look at technology, and if we talk about the NDL and all the other things. We are talking about exploiting technology, evolving technology, developing technology, using technology for purpose of society. So when we are looking at technology, what has technology done? Very interesting. It has shrunk space, it has shrunk time, and it has shrunk matter. For example, I remember when I was in IIT Kanpur graduating in 1967-68, that time a small little computer was housed in a room as big as this. And we had to take off our shoes, literally before going in, wash your feet with Dettol and walk in there. Today, it's interesting, this little toy which I carry in my pocket is a million times faster than that and whatnot, and we don't care even. I mean, it falls and whatever may happen, but nothing really takes, not bothered. So that's what has happened, shrinking of space, matter and time. And therefore the paradigm and the whole concept has shifted and changed. So technology is there. And in Hindi, when we say, we use a term, dunya hai muthi mein. Muthi means it's right here. You can clasp it in such a small space. And dunya means world. The world is right here in your palm. Now, important part, therefore, I won't go into the details of it, all of you are aware, but when we talk about intellectual property rights, there are various aspects that we talk about. One, when we are addressing issues of functionality, we use methods of science and technology to address things of functionality. That leads to inventions, and those are protected by a tool called patents. Expressions are protected by a tool called copyright, which we all talked about. So expressions, not functionality, expressions are protected by copyright. When you're talking about, for example, when any one of us went and bought a coffee mug, I'm sure all of us have bought a coffee mug. None of us probably went to the shop and told the shopkeeper, please pour coffee into it, I'll drink it. And only if I can drink coffee from the coffee mug, I shall buy it. We were all guided by the looks of that particular coffee mug, and we went and picked it up, provided, fitted into my, the cost that I wanted to spend money, and there were hundreds of them. I picked up one. Why? Because I like the looks of it. So somebody must have created that looks of that coffee mug, and that's protected by a tool called design registration. So in the field of intellectual property rights, we have different tools that protect different aspects, creative aspects of the human mind. So patents protect inventions which are linked with functionality. Copyright protects expressions of the human mind. Design registrations protect the looks, the aesthetics, disregarding the functionality. It's very important. It's the third tool of intellectual property rights. And interestingly, there are many other tools, but let's stick to 4. And it's interesting that I asked my 4-year-old grandson, I actually bit an apple and put it on the table and says, what is this? You know what he said? He says, iPod. He did not say it's a bitten apple. Now imagine a 3.5 or 4-year-old child looks at a bitten apple and says iPod. That means somebody has created that in his mind, that when he sees a bitten apple, he doesn't think of apple as a fruit, he thinks of iPod. And that's called a trademark. That's the power behind a trademark, where you make an association between a product or a service and who's really offering that particular product or service. That's the power behind trademark. Okay? So if you stick to these 4 tools of intellectual property rights, the whole concept is that if for example, there could be a 4th way of protecting it, and that is, I just don't tell you what I do. I keep it to myself. That's the biggest protection. But is that a desirable protection in society? For example, I don't know how many of you come from this beautiful town in India called Hyderabad. It's interesting, there's a grand old man in Hyderabad. every year for the last 30 or 35, 40 years. Once a year, he holds something like a camp where he advertises that if you have asthma or breathing problem, come to this camp. And what he does is people stand in a long queue. He takes a little fish, puts it with something, he opens your mouth and pushes it. And until you have actually got it in, he doesn't let you go. To this date, as I speak, nobody knows which is that fish and what he puts into your mouth. But there's general belief that asthma actually goes away. Now, he's not passed it on to anybody, including his sons. That's secret. He protects it. Now, is it desirable? Not desirable? We are not making value judgments of that. That's called a trade secret. Now, the interesting part is, so you can use a variety of tools. Now, why did the issue of intellectual property rights come about to start with? It came about to start with, that was the grand thought process and the philosophy of intellectual property rights, is that if you've done something creative, which you think will be useful to society and you want protection for it, disclose. Make it known to society. So the whole concept and the paradigm of intellectual property rights came about saying that disclosure is mandatory. That if you don't disclose, the government in a quid pro quo will not give you that particular protection. So if you want a statutory protection from the government, you disclose. So that's a very important part. So disclosure is the first part of any intellectual property rights system. It's wrong to think that you keep to yourself and the government gives you a right. No. The government says, please disclose. But disclose in a format, in a manner that does not mean I can take a guitar in my hand here and sing in front of you that this is what I did and the government will give me protection for that. There's a format. So a rock concert does not give you necessarily the protection for everything that you're talking about. Okay, though it may give you popularity. Now the important part is, therefore, how do you strategically use this? And to do that particular bit is very important. And the whole concept of intellectual property rights is not universal, it's not international, it's territorial. And that's one of the issues that we will be, we are groping with. That because it's territorial, what is true in India is not necessarily true in Bangladesh, is not necessarily true in Nepal. Forget the United States and the other parts of the world. So the point is it's territorial. The ownership is territorial. If the ownership is territorial, then you have built into these laws not only the rights that are given to you, but also territorially for each of those laws, there are some exceptions and limitations to those rights. And interestingly, those limitations and exceptions also vary from territory to territory, which means the exceptions in India are not necessarily valid in the United States, and what is valid in the United States is not necessarily valid in Australia or wherever. So we need to understand the rights. We need to understand the limitations of those rights. We need to understand the exceptions to the rights, so that if I fall within those exceptions, I'm not infringing somebody's right, therefore I can use it freely without fear of infringement. But then that particular part is again territorial. There's nothing international about it as of today, as I speak this hour. So the question that comes in are all those aspects, and then another very important part in all these laws is, on one side you have the rights, on the other side, as a right holder, you have a responsibility. That's defined in the law. So it's a balancing of rights and responsibilities on one side. On the other side, which is very important, that's why this subject becomes very interesting, and that is, if I as a right holder do not meet my obligations that the state, that territory, the state expects of me, then what happens? What are the consequences of my not meeting those particular obligations or responsibilities within that state? within that territory that gave me those rights. So the question is that we need to address these again territorially. Now, having looked at this territorial aspect, which is very important, and therefore we now look at it not just in terms of territoriality, but in terms of now looking at it across boundaries and cross-border issues that come about, that if all this was so territorial, then the issues that obviously come about is accessibility versus affordability and the ease of accessibility. Very important. And that's, I have purposely not used, very legal terms. I have not used very technical terms, but this term called interoperability and all those particular things are all embedded in these particular words. Very important. So we need to assess all this. So coming to, for example, when you're looking at the digital libraries, and when you look at digital libraries, I'm not going to details because then I'll be taking coal to Newcastle, and I'm not doing that. I'm talking, this is all standard. The 5S framework for digital libraries, we talk about these different models, and we have the primitives, the formalisms, and the objectives. All that means in this particular matrix is who are the stakeholders, who are involved, and how do you really address all these issues. And at each one of these particular blocks, matrix, intellectual property rights, issues related to intellectual property rights become very important in this. And therefore, what looks simple now becomes horrendously complex. It's a multi-parameter problem. Then how do you address this multi-parameter problem, in the framework of a digital library? First of all, does law define what is a digital library? Very important. Does law define what is a library, let alone digital library? And I'll come to that part later. So in this particular framework, we need to go into each one of this. For example, if you look at this, all these parts here onto these constructs out there. When we look at, for example, the graphs, nodes, links, labels, hierarchies, etc., and we look at metadata, first question you need to ask, does metadata belong to anybody? Is it protected by any intellectual property rights? Big question. Some say it doesn't belong to anybody. They say they only created it, but if I created, am I not owning? So who owns metadata? Can you take, can you create your stuff, link it with some terminologies which I have used, so that when you access your stuff or link it, my stuff also comes in automatically into it? Issues. We need to understand the legal implications of these technicalities. So this is something that we need to look at very carefully out there. So I just thought I would take you, in the time that I have, another 10 minutes, a few 4 or 5 cases that have taken place. I won't go into details. The details are in the slides and everything is available to you later. But I won't go into the nitty-gritties of it. I just want to raise 4 or 5 issues and then come to concepts in the time that I have with me. So if you look at it, all of you are familiar with this Google and Microsoft, what is happening February 2017, where Google and Microsoft, in a committed agreement with the UK government and creative industries, will demote websites that have repeatedly been served with copyright infringement notices so that they do not appear on the first page for common searches. Search engines, autocomplete functions, etc. shall remove the terms. So the question is that this is a form of self-governance. So the concept of self-governance is now taking a different turn, right? So providers of this type. Why? Because if you give access, then are you helping in promoting piracy? Or have you taken sufficient care to filter out the stuff that ought not to be there without consent? So that's the first part, which is very important. So compliance with with the code will be monitored by Intellectual Property Office IPO for the next. So this is something as an experiment which is going on. Whether this is the right model, debatable. But these are issues that we need to open up as we talk about issues of digital libraries and access to information, access to knowledge. The next, which I thought I would point out, this thing called the Pirate Bay. It's an old one. Again, just interestingly, it all started off with some of these people where they operated a single digital files. And what did they do? They just created a system, let it open, so that people can exchange among themselves. They came and said, have I done anything? No, I only created a platform. Where he comes to this platform, she comes to the platform, they exchange. So what have I done? I'm not exchanging knowledge, I'm not exchanging information, they are doing. So what is the legal position on that? Or what was the legal position then? The legal position was that because they only created this and they stored and put them and helped people, when you looked at it, the courts looked at this very, very carefully. We won't go into great details, but the short story is that they were told that you're infringing on the copyright of the country. So therefore, please get off. They went off. They came back with another version. They were again taken on in 2012. Interestingly, now see where it goes. Why I took this particular case. That when court, see the interesting part, the people who were running this, Pirate Bay, then said it's a human rights issue. So now from intellectual property rights you go to human rights. So where did they go? They went to the human rights panel. You can see there, ECHR. ECHR upheld the decision. They said, well, it's curbing of human rights. Then what did they do? Interestingly enough, they went to the European Court of Justice. The European Court of Justice held it as well. So what you can see is that the court systems around the world have started looking at these also rather carefully. You can't take it for granted now anymore. Moral of the story is that even the European Court of Justice is looking at it rather in a. So there it says that cannot be. You cannot say I was unaware what the two of them were doing. Then what the hell were you doing? So you can't just wash off your responsibility. Therefore, running a NDL, you cannot come and say I was not aware what people were doing. You better be aware. So the important part is I go to another one called NewsBin, the 20th Century Fox and these people. So they went into it. They operated to locally identify unlawful copies of films. So when they went into this, again the courts came in and the court says, well, off you go. So they went off, and after they went off, the categorization, etc., they went off, they came with a second version, and finally, what happened? BBC and all the others were asked by the court, please block that. So when we are talking about access to what? And what is your role while giving the access? So important part is what are you giving access to, and how are you giving the access? You have a role to play as of today, as we speak. Now we go to the next one, rapid share. Now the reason I've taken these three cases only is just to illustrate that as you go from jurisdiction to jurisdiction, concepts have not changed. Right? Thought process has not changed as of today. So when you talk about rapid share and all these things, again the court in Hamburg, copyright infringement recurred to all these particular things because they were put for sharing. So these are all sharing. I'm giving you examples of sharing. Now it's a sharing is wonderful, I'm so broad-hearted. Okay? But you can't be broad-hearted with a polluted heart. Very important out there. So coming back to this, see the regional court in Hamburg, they did it to avoid liabilities. Rapid share was ordered to apply heavier filters. So now people who are sharing there's more responsibility on the people sharing. What sort of filters do you put, how do you put, where do you put, etc., out there. And then it even went to the higher courts, the Supreme Court, and they all held as of today that while sharing you better be careful. So I created a term earlier for my students. I said, look, share with scare is one, which is not desirable. But if you're familiar with concepts of intellectual property rights, from scare remove that letter S, share with care. So do share, but not with scare, share with care. So the question is that when we produce all these NDLs and other things, the issue is what care do we take? Right? And in that, I'll touch that last part of it in the last 5 minutes out there. And again, the issue of trademark came in, that there are two organizations. Now this fellow puts in his metadata certain link terms. So when you search that, you get mine. And I link it in such a way that when you're looking for him, you actually come to me. Right? Again, there are court cases of that type out there. Very important. Now while sharing, these are issues of copyright, trademark, but then you're using technology, functionality. So you may be infringing patents as well. So we need to look at those also carefully. Contracts, licenses, I won't go into details because Jill has already talked about licenses and concepts of licenses that come in, and copyright laws have specific chapters on licenses. And I'm not going into those details. This of course, but the important part where I want to end this talk in the next 5 minutes is the following, that now we are into an era of artificial intelligence. I'm not calling them computers, I'm not calling them robots, because they are beyond all that. These are systems, I'm not calling them machines, and see, interestingly, I'm saying I'm not calling them. So I've already personalized them, given them a personhood. Interestingly, that these are autonomous self-learning systems. Software that learns by itself, creates. And when such a system is used, the first question, who is the author? Because the system is created on its own because it learned. These are self-learning systems. So the question comes in, if it's an invention, who is the inventor? If it's the creation of a text or a musical piece or a piece of art, which has happened, I'll give you an example of that. Who is the author? Who is the painter? For example, there were two deep learning systems, which were given several paintings of Rembrandt. So this system studied all the Rembrandt's paintings. And this other system also studied Rembrandt's paintings. Software. And what they did, this one learned that when Rembrandt draws the nose or paints the nose, it paints it this way, and the eyebrows are like this, and the cheeks are like this. And then now creates a Rembrandt painting. I'm calling it creates a Rembrandt painting or Rembrandt-like painting. Because if I call it Rembrandt painting, it'll be it's a plagiarism. So it's a Rembrandt-like painting. And the other system now criticizes and says, that's not quite correct. It should be something like this. The two systems are now communicating with each other. Right? They're self-learning systems, not people. So the question is, should we give personhood to such artificial intelligence systems or enhanced systems? It's a big question in law today. Authorship, ownership, liabilities, very important. Only yesterday, Germany has introduced, self-driven buses in certain places. That bus creates an accident. Who is liable? Big question. So such questions are going to be extremely important, and therefore in the whole concept of digital libraries and others, where I would like to end, it's interesting that when India, and I'm surprised that we did such a mistake, I call it a mistake. I've told the government, and I think we need a change. When we changed our copyright law, interestingly, in the exceptions and limitations of our copyright law, we brought in some exceptions to what we called as non-commercial public libraries. Non-commercial public libraries in India are governed by state laws. There is no central law, which you were referring to. And a lot of things have been done, nothing has happened so far, which you were absolutely correct in your presentation. So those are, and why on earth did we bring in, that term was not there in the earlier law. It said public libraries. That's even worse. But non-commercial public libraries, therefore the library in IIT Kharagpur is not classified under a non-commercial public library. Therefore it doesn't come under those exceptions. Contrast it with the UK. In the UK you have a Public Libraries Act. And all those public libraries come under that one common act, federal act. I mean, it's not a federal act, but okay, it's an act. So you have to look at all these things. And so I'm really surprised that we made such a big mistake. And I'm surprised that the library community in India has remained silent about it. Why? We need an uprising on that. It's interesting, I will just end the talk here only to mention that I got interested. I have been a person essentially in the area of technology and patents, etc., etc. But in 2003, a blind professor by the name Professor Sam Tarapurwala from St. Xavier's College in Bombay, he came to me. He said, sir, we want to bring, and they run something for the blind. I'm sure you're aware of what is happening in St. Xavier's College in Mumbai. I've been involved with them for the last 40 years in various things. But interestingly, Sam came to me and said, sir, we want to bring this from such and such country, and they've sent us a letter. Does this infringe your copyright law? So I said, I have never applied my mind to it. Okay, I looked into it. I said, yes, we do. As a result, the first thing I did was, being a member of the board of the Intellectual Property Rights Practitioners Association in India, I called all the top lawyers in this country. I said, look, I want the blind people to give you a talk. So Professor Sam Tarapurwala and his people gave this talk to all of us in an audience like this about the issues of the blind. And I say that was the first time when the blind people opened my eyes, made me see light in copyright. We then created a movement in this country, and that movement ended up with the 2012 amendment, where we have special provisions for the visually challenged. I think the library is challenged. Information services is challenged. Knowledge systems are challenged. It's time that we look into our copyright laws and we actually raise this, centrally, maybe, and just about 6 weeks ago, I was giving a talk to about 200 librarians in Ahmedabad. People came in on an Inflibnet. I was called by Jagdish Arora to give a talk. I gave that talk. And during the question answer session, a lot of librarians raised questions. So I told Jagdish that, look, we need to create a manual for our librarians. What they can, what they should, what they can, what they cannot. Interesting, then everybody raised their hand up and says, yes, we don't have such a manual. So I said the manual project starts now. No money, no project, no proposal, the manual project has started. It's 6 weeks now. I just reviewed it yesterday in Ahmedabad. Out there, it's progressing. So Dr. Anil Kumar in IIM is now coordinating with the librarians, has created and also coordinating with NDL, creating a thing what the stakeholders need, what the issues are, and I'm coordinating with the lawyers. I'm going to put the two together in the next few weeks, and hopefully by about February, that's my commitment, without asking for a single rupee from anybody, we will create that manual, which then with NDL and with InflibNet, we'll try and put it through into a public domain out there on an open license. Thank you.
Thank you so much. Thank you so much, Professor Ganguli, for the very enlightening speech and presentation. We are now done with our session, and I'd call, because of the limitation of time, just a maximum of 2 questions. If you have any question for Professor, please.
Yes. Thank you very much. Very enlightening lecture. I'd just like to point out and just make a few comments on this, is that the term intellectual property started to come in use in 1963. And before that, the concept didn't even exist. Now, in common law countries, nobody owns knowledge. That's a fact. Nobody owns knowledge. What you own is a copyright, which is a monopoly. And I didn't hear you use the word monopoly at all. It is not a property right. And there's a number of court cases in Canada, Britain, and the United States, I don't know about India, but showing that it is not property, it is a copyright. And I liked what you were saying about that it comes with obligations, because monopoly, when you're granted a monopoly, you have obligations as well. It's not all one way for them. And I think for educators, we've got to stop thinking in terms that this is property. We've got to call a spade, and it's a monopoly. It's a privileged monopoly that we grant to the authors, to the creators, and that's what it is, and it is not property. And we really have to get away from using that term. They're using it because they're trying to morph the copyright system into something that it was never intended to be, and that is a property system.
See, the whole jurisprudence of property comes in because here is, though it's intangible, it's an intangible property. In that sense, it's not a property the way we understand a property, but in the jurisprudence of property, I can buy, I can sell, I can rent, like every other thing, I can do that. But what am I doing? And you're absolutely correct. I'm trading with my monopoly.
Yeah.
Right?
Yeah.
So the monopoly is the overriding factor. You're absolutely correct. And in doing that, so monopoly, if I either overuse my monopoly or misuse my monopoly, the law has a provision on one side. And as you rightly said, that when you look at common law countries, I'm going a bit technical in that, common law countries, and if you go to civil law countries only, then what happens is in common law countries, the courts can give interpretation which goes beyond the law in public interest, in interest of the society and others, whereas in the other countries which are not common law countries, for instance, the UK is a common law country, India is a common law country, US is a common law country, but if you go to the non-common law countries, then what happens there is the law becomes the boundary which binds the courts. So important part here is that, and you're right, what we need to do is, if we think that as society there's something good for us, rather than being emotive about it, and that's where the logic, that's where all the debate moves away into the emotive sphere. Rather than being emotive, we have got to bring in a certain amount of logic so that we can debate the pros and the cons and then take it from there. And I see light at the end of the tunnel if we do it that way rather than being emotive about it.
That will be the last question.
Yeah, sir, this is regarding to that Delhi University photocopy issue. With light of that High Court decision, can it going to have any impact on digital libraries, especially which are dealing with education? So what is your views?
See, if you read that 82-page judgment of Justice Endlaw, this is a court case that took place, and the judgment was given about a year and a half ago from the Delhi High Court by Justice Endlaw. The issue was that in the Delhi School of Economics, there is a photocopy shop inside the school, and what they do is they go on, photocopying. I don't use the word Xeroxing, the photocopy, okay? Because the word Xeroxing brings in trademark, so I don't do that. It's photocopying, okay? So they photocopy course packs, and they sell it off to students. So obviously all the publishers came up in arms and said, this is rubbish. How could you do that? It is against all aspects of copyright law. So when this matter came to Delhi High Court, and there's a whole bunch of things, there was first an injunction, and then Justice Endlaw heard this particular matter. He interpreted. He gave a very creative interpretation. I may not agree with that fully. That's a separate issue, but that, I'm not here to give my opinion on his judgment, that I've debated them separately. But he gave a very creative interpretation of the exceptions and showed that those course packs fall within the exceptions in the Indian copyright law. Therefore, he allowed it. Interestingly, that none of the publishers challenged that decision. They've all remained silent. They've actually withdrawn their appeal. Now, that's a separate issue. It's a highly politicized, highly political, emotive issue. But that judgment is specific, and if you read that, I forget the para number, but if you read that, he clearly said that my interpretation is for this set of facts only. Therefore, if you read that judgment, it is only restricted to those set of facts. Now, you change the context changes. Therefore, you cannot come forth and say, can I take it for the digital library? The answer is no, not necessarily. So the way you have to do is, you have to contextualize it. And therefore, in law, what we do is, putting the facts and contextualizing the facts is a very important part. So if you can translate the digital library thing into this particular context and show it that it fits into this box, you may be able to argue your case, not otherwise. You get the point?
Legal advice given fee.
Okay, thank you so much, Professor Ganguli. Now, if you have any other questions, please keep your questions for offline, or grab him outside. I think he has got enough business cards. Okay?
Oh, that's lovely. Thank you very much.